Good morning, everybody. Thank you all for joining us. We just have a few more folks kind of straggling in from the waiting room. And there we go. We are all in. Well, thank you all for joining us. I'm going to start us off today like I usually do with our Zoom housekeeping tips. You actually might see that your chat icon is flashing. I just put a message into the chat with some information about how to ask questions both today and in advance of our next Q&A or future Q&As. The chat icon is probably on the same location in your Zoom app as all of the other buttons, including your start and stop video buttons and the audio button for keeping yourself muted during the Zoom. We do ask that folks stay muted unless you want to unmute to ask a question. It just cuts down on background noise. You're also welcome to be on camera or off, whatever is more comfortable for all of you. And we do remind everybody every week, and I'm going to remind you again this week, that we're not here to give legal advice. We're here to just discuss general legal information that we think is broadly helpful and applicable to community associations in Washington State, including board members, homeowners, managers, and all of us that serve this type of community. So please keep that in mind when you do submit your questions. If it's getting really long, multiple paragraphs, or you're sending us excerpts of your governing documents, your question is very likely too specific and asking for legal advice, even if you're not meaning to do that. And in that case, we just will email you, Chelsea will email you back and tell you that the question is too specific and we can't cover it. Don't shoot the messenger. Chelsea's not the one that makes these judgment calls. It's me that says, no, we can't answer a certain question because it's too specific. But sometimes we also will try when we can to cover that topic generally from a broader perspective if we think that it's, again, widely useful information. We also remind people that the chat function is for questions or requests for clarification, not for discussion like you might see on the CAI national message boards. It's been a while since we've had any kind of issue with that, so I think I can keep that reminder pretty brief. We do also want to remind everybody that we've been doing some Q&A videos. Like at the beginning of some of our Q&As, we spend anywhere from 10 to 20 minutes talking about a particular topic that we think is of interest or really important, things like legislative changes, meetings changes, stuff like that. So when you go to our YouTube channel, you can look at the Q&A videos, and if there's a primer at the beginning of each video, we'll call that out in the description or the list of topics for the Q&A video. We also want to tell everybody that WSCAI has a WUCIOA resource guide that is now available that you can purchase directly from them. Proceeds from the sale of the resource guide go to support the Legislative Action Committee, which is in the process of trying to hire a new lobbyist because we lost our longtime lobbyist after the end of last legislative session. The resource guide was contributed to by attorneys and managers and other professionals that serve community associations in Washington State, including one of our attorneys who had input into some of the subjects in the resource guide. So if you're interested in having a written resource that sort of gives you a 30,000-foot view about what WUCIOA for All is going to mean for communities that haven't been governed by WUCIOA before, contact WSCAI to learn more about that, and their website is WSCAI.org. And for those that don't know, WSCAI means Washington State. It's the Washington State chapter of the Community Associations Institute, which is an international organization that works with community associations and all the different types of vendors that serve community associations. And they host an annual conference, the Washington State chapter does, called CA Day. It's coming up on October 18th at the Washington State Convention Center. We're going to be there. We'll have a booth. We hope a lot of you guys will come and say hi to us at the booth. Katie is going to be presenting again this year, and we'll announce this more specifically when it gets closer, but we are not going to hold a Q&A the week of that conference. So again, that's October 18th, and that's CA. Learn more about that on the WSCAI.org website. Finally, one last reminder that we've been giving you every week is that there were many changes to WUCIOA that took effect on July 27th, which already govern communities that are under that statute, meaning those changes took effect, most of those changes took effect July 27th for those of you that are already under under WUCIOA. There is another group of changes that are going to go into effect for everyone, including non-WUCIOA communities, effective January 1 of 2026. And those are primarily related to meetings and collections notices. So you should be paying attention to that. We've been covering that stuff pretty frequently on the Q&A. I'm sure that there will be presentations about that. Not I'm sure, I know there will be presentations about that at CA Day in October. So please keep that in mind. And I think that's it for the announcement. So I'm going to go ahead and jump us into the questions. Our first question is this. Is there a specific language in the community association statutes that permits associations to use an electronic voting platform for votes at their annual meetings? So the short answer to this question is yes. Electronic voting is specifically authorized in Washington State. All of the common interest statutes allow for voting in person, by absentee ballot, or by proxy. And RCW 6490.010 subsection 5 defines a ballot as, quote, a record designed to cast or register a vote or consent in a form provided or accepted by the association. So the short answer to this question is essentially that if your association allows for electronic voting, then electronic voting is allowed under our statutes. If you look at 6438, which is the HOA Act, it talks about electronic transmissions, which means any electronic communication that can be retained, retrieved, and reviewed by the sender and the recipient of the communication, and that can be reproduced in a tangible medium. So part of what that means is that whatever voting platform you are using does need to allow you to be able to produce copies of the votes and retain them for the association. Do also keep in mind that there are confidential ballot provisions in WUCIOA that have taken effect for WUCIOA communities already, and which will impact all communities when WUCIOA for All takes effect in January of 2028. So any electronic voting platform that you're using needs to provide for confidential voting and balloting as well. And there's a follow-up question in the chat whether the copy that has to be retained is the vote tally or the actual ballots. I think you need to be able to produce a tangible record of each vote, not just the overall tallies. I think that covers that question, but Tima, if you have anything to add, feel free to jump in.
I do not. Moving on to the second question. I believe can answer the question I put in the chat at today's Q&A session, so this was last week, that the board cannot distribute phone numbers to owners. Only names, addresses, and voting percentages, if applicable. RCW 6490-495 Section 3 I refers to redacting unlisted phone numbers. Can you direct me to the correct statute that says no phone numbers should be distributed? The short answer to that is there's no specific area in the statute that says no phone numbers should be distributed. However, because, and this is what Ken had said, so I'm just going to replay for you what Ken's perspective on this, which was because there are no published phone books any longer, like we used to get, for those of you who remember that, we think all phone numbers should be considered as unlisted. Therefore, we consider the risk of publishing phone numbers without permission from an owner or a resident to be unnecessary for the association to take on. So essentially, all phone numbers should be considered unlisted. And because we already have the statutory restriction on publishing unlisted phone numbers, it seems that the best plan of action here is simply not to distribute them. Although there isn't a specific area in the statute that says you may not distribute unlisted phone numbers. You know, and again, back to the records, the records section of the statute states, records retained by an association must have an unlisted telephone number of any unit owner or resident redacted or otherwise removed prior to disclosure. So between, you know, that being stated, that being the case, and the fact that from a practical standpoint, no one's phone number is published any longer, it's simply not a good idea. Valerie, did you want to add to that?
No, I want to clarify because I think you misspoke unintentionally. The statute specifically requires an association to redact unlisted phone numbers, which you said in the beginning and you said in the end, but in the middle, I think you just misspoke. So I do want to make it very clear that the record statutes specifically require an association to redact unlisted phone numbers. And unless somebody can point me to a place where my cell phone and Tima's cell phone and Chelsea's cell phone are listed, then I think they are by default considered unlisted, which is the point that Ken was making last week. All right, next question. The issue of payments for work not yet performed came up, and we would like some more guidance on this. We routinely have vendors asking for 50% down payments before they can begin work. We work with a lot of smaller companies on some bigger projects, and not all of them have the capital to purchase materials, hire additional staff, etc., to start a larger project. They have been reliable for us thus far, and they offer competitive pricing that we otherwise wouldn't get from a larger company that would not ask for such a large down payment. So this isn't, there isn't a specific question other than just asking for some general guidance. And I think the position that we generally take on this is certainly, as with anything, the larger the dollar amount of the contract that you're looking at, the more carefully you should assess the risk of any action with respect to that contract. We think that paying for work as it is completed is reasonable. We think paying for material as it is delivered is reasonable. We have had clients pay weekly or biweekly for work as it's completed so that contractors can then turn around and pay their employees, as the project is ongoing. We think that there are ways to protect the association while still accommodating small contractors that do not require large advance payments to vendors when there's no work yet completed. And I think part of why we are so cautious around this is that we've seen, some scenarios play out where our association clients have been burned by making these 25% or 50% upfront payments. So some things to keep in mind. One is that the contractor's bond that a contractor has to post with the state is no more than $30,000. So that is the most that an injured party, like an association, could possibly recover from the state if a contractor takes deposits like this and then ghosts an association in the middle of a project or before even starting. And that $30,000 goes against all claims against the contractor. And if the contractor is a bad actor, you can bet that there will be other clients that are also trying to make claims against that bond. As with many things in life, and I think, like I said at the beginning of this, you're balancing the risk associated with making the payments in advance against the benefit of having a vendor who will do the work. And it's not just small contractors that ask for these types of down payments. We've had clients write checks in excess of $300,000 as a down payment on a project that has not even started yet. We've had one vendor that asked a client for 35% when the contract was signed, another 35% before they would start the work, and another 20% when the work was halfway completed, which would leave only 10% of the contract price to ensure that the second half of the project would be completed. So, can I say that paying a 50% down payment is never reasonable under any circumstances? No, that's not what I'm saying. I think it's possible that paying a 50% deposit for work to be performed could be considered reasonable in certain circumstances, but just writing checks because a contractor asks you to do it is not. And we think that it's a good reminder right now to talk about what the board's duty of care is when it comes to making any decisions on behalf of the association. The board has to act in the best interest of the association as a whole. Of course, it has to not act contrary to the governing documents, and it has to act based on objective information and after having made an adequate inquiry into the matter at hand. And so one of the things that you could decide as a board, I suppose, is that, look, our manager has worked with this vendor 20 times on behalf of other clients, and they've never had an issue with them. That's a piece of objective information you can rely on in supporting a decision to write a check for an upfront down payment. before work has started. But I think just doing it because you're asked to is where the problem comes in. Tima, did you have anything you wanted to add to that one?
No, I think that covers it. We're just, again, the duty of care is to act reasonably. And so whenever it comes to making payments for work to be done, you have to look at it from that standpoint. And certainly you don't want to put yourself in a position where you've spent money and you can't get it back, or the
Yeah.
work isn't going to be performed.
I did think of one other thing that I would like to add. This question is really different if you are talking about a $20,000 contract versus a $500,000 contract, right? It is maybe within the board's discretion to say, like, it's a reasonable risk to write a check for $10,000. We think this contractor is reputable. They don't have any, marks against their name with the state. Our manager works with them and likes them, whatever, right? I think writing a check for $250,000 to a contractor, almost regardless of who it is, with no work having been performed, no materials having been delivered, is a very different thing. So as with anything, the magnitude of the risk varies based on the size of the contract, the complexity of the work that's being done, the reputation of the contractor that you're working with. So if you're dealing with this question in a particular association, it also might just be worth a quick phone call to the association attorney. Also, I would be remiss if I did not say that anytime you're dealing with a contract that the association is going to sign, you should consider having the association attorney review it. And again, I understand sometimes with smaller contracts that the cost of the attorney review sometimes feels like too high in comparison with the value of the contract. But of course, that's a sort of sliding scale kind of issue. The bigger the contract gets, the greater the potential for risk or liability in signing a bad contract, which we see way too many of. And so that's another thing that I would add, just related to this topic, is if you are entering into contracts with vendors, you should always be asking your association attorney, hey, is this a big enough one that we should have you review the contract? What would the cost be? What is your thought about this provision, about the deposit down payment, stuff like that?
Yep, good point.
Yeah.
It's all relative, so to
Yeah.
speak.
Yeah.
Question 4. An unmarried couple moved into the HOA a couple of years ago. The title to the house is in her name. The CCRs say that only homeowners can be board members. Now that they are married, is he considered a homeowner? So the short answer to the question is that under Washington state law, the property might be considered community property, depending on regardless of what the title says. That depends on a variety of factors. And I don't have enough information to make that determination here. But regardless, from a practical standpoint, this may be a distinction without a difference. The owners are married and they're living together in the unit. They're paying the assessments. Potentially, they're also paying a mortgage. They're both jointly vested in the property from a practical standpoint, and they would very reasonably considered homeowners, unless there's some specific authority in your governing documents that defines a homeowner as only to be someone who holds record title. If you have some type of requirement in your governing documents, that would be the only thing I can think of that would restrict that. And if this is really about whether or not the person can serve on the board, I guess I have a question, which would be, why would you not want this person to serve on the board? It's generally difficult to find active board members, people who want to be members of the board. Sometimes it can be very challenging to recruit board members because, as many of you on this call know, it's a lot of work. It's unpaid. So if you have someone who's stepping up, who's invested in the community and wants to be part of the board, I would, say, unless there's some really specific reason you don't want them to be on the board, that this would be a welcome addition to your board composition. Valerie, did you want to add anything to that?
Yeah, I think I would take it one step further and say that he is probably considered an owner unless there is specific information that suggests otherwise. Because Washington is a community property state, and that means that unless the married couple executes really specific documents saying otherwise, the property is owned in common by the two spouses. Just because somebody's name isn't on the deed, that does not mean they are not an owner of the property, especially within this context. So one of the suggestions that I would have is, if you're looking at this in your community and for some reason, as a board, you want to make a determination that this person is not a homeowner within your community who is eligible to serve on the board, I would strongly recommend that you consult with your association attorney before making that decision and taking any action to exclude them from board service. All right, next question. Our HOA board approved the meeting minutes from a board meeting at the following board meeting. A board member keeps insisting that we have to amend the minutes to include a lot of discussion and personal information, or demands that all of their proposed amendments to the approved minutes be attached to the minutes. The person keeps bringing it up at every meeting. Can you provide some guidance into what should or should not be included in the minutes and how to stop this topic from taking up a lot of time at every meeting? Absolutely. So board meeting minutes do not have to contain detailed discussion or personal information. Minutes are intended to be a summary of the actions taken at a meeting, not a transcript or a detailed description. So minutes should contain things like a note of when the meeting was called to order, the general order of business, the name of the association, the type of meeting, the date and time of the meeting, who was in attendance, general order of business. And the minutes should contain any motion made, whether it was seconded, and the results of the vote on that motion, whether it was passed, rejected, tabled for the next meeting, etc. If a board member objects to a particular motion that passes and asks for their objection to be noted in the minutes, that needs to be included as well, okay? But other than that, minutes do not have to contain any other additional information. The board can certainly decide that it's reasonable to include factors the board relied upon in making a certain decision, that there's some discretion, right? It doesn't have to just be a super short bullet point list of motions, but it absolutely does not have to be an exhaustive transcript. And also, boards govern by majority rule. And the fact that one member is insisting on a different outcome than the one the board has settled on does not require the board to take the particular action being demanded by that member. So assuming that the minutes in question contain all of the stuff that I just listed earlier in my answer, and it makes it clear that what motions were made, what votes were taken, what actions were decided upon, the board can vote to reject this member's motion to amend the minutes and can decline to consider repeated future requests for the same thing. In other words, just because this board member keeps bringing it up at future board meetings does not mean that the board has to go through the same discussion and decision process over and over again. And if you guys want to look at the statutory reference for the minutes, you can look at RCW 6490-445 subsection 4. All it says is that the minutes of all meetings have to be maintained in a record, and the decision on each matter voted upon at a board meeting or unit owner meeting must be recorded in the minutes. You can also find additional information on minutes in Robert's Rules of Order if you want further detail that is, I think, unnecessary to this particular question. But sometimes it's interesting reading, and some communities like Robert's Rules of Order a lot. I think the bottom line here is, if you've got a board member who is repeatedly insisting on a different outcome than the one the board as a whole has voted on, the chair of that meeting needs to shut that board member down going forward. I think if you haven't, at a subsequent meeting, if the board hasn't officially voted that no, it is not going to amend the previous minutes, you should do that, just so that there's a record that you did consider this one time. And then notify that board member that future requests for the same thing are just going to be ignored by the board. You don't have to keep having the same conversation over and over again at future board meetings. Tima, did you want to add anything to that?
I would only distinguish this by saying that, if there's something recorded in the minutes that a unit owner or homeowner has a question about, and they're asking for additional information, unless there's something confidential, unless it's confidential documents, you can always provide additional information if there's something that someone's requesting. But as far as what needs to be recorded in the minutes, it's very clear what needs to be there. So it just seems like that there's no reason to, like Valerie said, if the board member's simply being difficult there and no one else agrees with them, there's no reason to go to the extent of all of this that's being asked. The next question is, A member of our HOA board got frustrated at our last board meeting with bad behavior of other board members and left the meeting saying he quit. Is his resignation valid, or does it need to be written to be valid? So um, the short answer is there's nothing in the statute, there's nothing in statutory authority that requires a board member to resign in a formal way. The statutes provide specific guidance about electing, removing, and replacing board members and what their enumerated duties are. If a board member, from a practical standpoint, if a board member no longer wishes to serve on the board, it's very difficult to force someone to do something that they don't want to do, especially in a voluntary capacity. That said, it may make sense to request that the board member draft a formal resignation notice to provide clarity for everyone who is on the board and for the association as a whole. That being said, the statute could be interpreted in such a way to say that a board member cannot resign. And I will quote the statute here. 6490-410, Section 2C states that unless provided otherwise in the declaration or organizational documents, board members and officers must take office upon adjournment of the meeting at which they were elected or appointed, or if not elected or appointed at a meeting at such time of election or appointment. And this is the last sentence here, says they must serve until their successor takes office. And so that it would be maybe a caveat there. However, like I said earlier, from a practical standpoint, I don't know how you force someone to stay on the board if they don't want to be on the board any longer. Valerie, did you want to add to that?
Yeah, the only scenario I can think about where you might want to sort of throw the book at someone, as it were, based on that last statutory clause, is if they're the last board member standing and they're trying to resign without appointing a successor. But in the scenario that was presented in the question, it sounds like there is a board meeting with other board members and just one person decided to flounce and quit. In that scenario, I just don't, I think they don't have to resign in writing. I do think it would make sense to note their resignation in the minutes for that board meeting. I think that would make sense so that there is some documentation of it. And then the board can decide at its next meeting whether to appoint a board member to replace that person until the next election, or whether to hold an election soon enough that an appointment is unnecessary. All right, I'm going to move us along to our next question. Can condo boards avoid the owner comment requirement by labeling the meeting as a study session or working session where no board votes will take place? The board will discuss the pros and cons of the agenda items, which will be voted on at the next regular board meeting without discussion. No. And I mean, I'm going to be a little bit blunt here. I'm a little flabbergasted that somebody was willing to put this blunt a question in writing, because your question is asking whether you can circumvent the very clear statutory requirements for open board meetings and owner comment periods by just relabeling your meeting something else. And so the first question that I always find myself asking when we get questions like this is, why would a board want to avoid open meetings and owner comment periods? What is it that you are doing at these meetings that you don't want your owners to observe? We have many clients that have been conducting open board meetings with owner comment periods for years without incident or with minimal incidents. Excuse me just for a second. For the most part, owners don't even care enough to attend, and those that do are largely calm and non-disruptive. And it just kind of blows my mind how many questions that we get making it clear that boards want to avoid these requirements. The legislative intent and the statute are very clear. Board meetings have to be open, and this is going to be true for everybody starting January 1, 2026. So even if you're in a community now that does not require that, in January 1, 2026, you will be in a community that requires this. They have to be open, and they have to allow for an owner comment period at the beginning of the meeting. There's a really specific reason why they moved the owner comment period to the beginning of the meeting. What is the point of allowing owners to comment on association business at the end of a board meeting when you've already voted on everything that's on the agenda, right? Even executive session. Executive session is the only part of a board meeting that the statutes specifically allow to be closed to owners, but those have to start in an open board meeting. You don't get to just hold a separate meeting entirely and call it executive session. You have to start in your open board meeting. Somebody makes a motion to adjourn to executive session for specific reasons. You adjourn to executive session for the discussion of a very small subset of topics that are allowed to be closed to the owners. And then you reconvene your open meeting, you make your motions, and you vote on those motions. So like I said, I'm being super blunt here. I'm flabbergasted that somebody was willing to put this question in writing, making it clear that what you are trying to do is hide your board discussions from your homeowners and avoid the owner comment period. It makes me really concerned about what your board is trying to do behind closed doors. And let me also say, this kind of question and this reaction to the open board meeting requirement and the owner comment period is exactly the kind of horror story that homeowner advocates are telling our legislators in Olympia, which is what is leading to legislation like this. So I think I'm going to go ahead and leave it at that. And Tima, you might, I don't know if you want to temper my comments at all or if you want to add anything, but that's what I got for this one.
Yeah, I don't have anything further to add. I think absent like a really valid reason, and those are clearly enumerated in executive session, what exactly an executive session is permitted to be used for. So outside of that, and even still, as Ken has said, every executive session must start with an open meeting. So even if you are having an executive session, you still have to offer unit owners, homeowners an opportunity to comment. Next question. I am reaching out to you to see if the Condominium Law Group has put together anything in writing to educate boards on the upcoming law changes. You and many other of my clients have reached out asking this question. We do have draft documents that are still in the drafting process, finalization. We hope to have all of those ready for distribution at CA Day. I'm hoping to see a lot of you there, or many of you, or all of you. We will be there in attendance, and we should have those documents ready. And after that, certainly you can reach out to us if you're our client, or to your HOA attorney to ask for those documents in PDF format as well. Val, did you want to add to that?
Nope, that's it. All right, our next question. Can an association determine that a non-owner occupied unit is considered a rental and part of the rental cap? The association has a rental cap, and there are a couple of owners that have family members living in their unit, and they are being counted as a rental. Most communities don't count family members as rentals, and any well-drafted rental cap would include a definition of who is considered a tenant and who is not considered a tenant. The banking industry, which is usually where this matters, right? For the purposes of reporting the percentage of your units that are rented out, it's almost always something you're trying to report to the banking industry when perhaps you might be taking out an HOA loan, for example. The banking industry does not define what tenants are, and it is entirely up to the association to define that on a self-reported basis when the bank asks. So the association would have the right to define a tenant as it chooses, again, provided that your rental cap is well drafted. So as long as your definition of tenant does not go against what's in your recorded declaration or a recorded amendment to the declaration, then you can adopt a rental policy that defines who is a tenant and who is not a tenant. Or again, like I said, that should actually be right in the rental cap amendment itself. And again, for the most part, relatives are not considered tenants. There can be some, nuance here. Some rental caps are drafted to say that, first degree relatives are not considered tenants, but other relatives are not. And so if it's a parent, a sibling, or a child, or a spouse of one of those people, then they're not a tenant. But if it's somebody like your second cousin 3 times removed, then it is a tenant. So there's some nuance there. A lot of folks think that whether somebody is paying rent is dispositive as to the question of whether that is a tenant occupied unit. Again, that is almost always not the case. You want to look to the language in your rental cap. If you can't figure out what it requires or what it allows in a particular community, then you should consult with the association attorney. But most of the time, again, not to be too repetitive, most communities don't count family members as rentals. Tima, did you have anything to add to that one?
No, I think that covers it, Valerie.
Right.
Okay, question 10. We are an HOA under 6438. Our community manager has told us that starting January 1st, 2026, WUCIOA requires the community to have open monthly meetings to discuss each request, naming the owner, lot, and project, then discuss each resulting in approval, denial, or needs more information. I have searched and I don't find a requirement for monthly meetings. Is our community manager correct? If yes, which statute says this and how does it align with 6490, 495 about privacy of unit owners' files if the request and response have already been made public via the meeting and minutes? So, okay, the short answer to this question is that the effective date, January 2026, WUCIOA does not require meetings to be held monthly. However, the open meeting requirement is going into effect January 1st, 2026. We've already advised all of our clients to start doing it now. There's no reason to just not to wait. Go ahead and get yourselves into that mode of thought because that is definitely going to be happening. And if you can visit, we have resources, I believe, in the chat. I think we added in a resource for the WUCIOA, the effective date and what's going into effect for Senate Bill 5129. But other than the requirement that meetings take place monthly, your manager is correct. And everything else regarding in her comment is correct. We need open meetings, we need notice of the meetings, and all of the other requirements for the open meeting requirement will go into effect. Simply, it's not requiring a monthly meeting. Meetings are, can be held they have to be held at least once a year, but as long as you're having regular meetings, we recommend them more often than that. Did you want to add to that, Val?
Yeah. So I want to clarify that this question was about ACC meetings, not just regular board meetings. And for those that don't know, ACC are just Architectural Control Committee meetings. And so your manager might be suggesting monthly meetings due to the frequency of ACC requests within your community and the turnaround time allowed for the association to take action on those requests. In other words, there are some governing documents that state if the association fails to respond to an ACC request within a certain period of time, the request is deemed to be approved. So you can schedule monthly ACC meetings and then provide notice of those meetings to the ownership and then simply cancel any meeting where there's no request to be considered. That is a lot easier to do than scrambling to schedule a meeting, send the required notice and agenda to the owners, etc., if you're only going to schedule ACC meetings when requests come up. So some of this is governing document and community specific because not every set of documents has a specific deadline for an association response time for an ACC request. But on the other hand, associations always have to act reasonably. And if your community, for example, is only holding ACC meetings once a quarter, and an owner submits a request a week after the last ACC meeting, is it reasonable for the association to wait 90 days before making a decision on that request? It probably depends on a lot of different factors. So Tima is correct. There is no statutory requirement for ACC meetings to be held monthly. There is a statutory requirement, or will be, that these meetings be open to the community, that notice of the meetings be given to the owners a minimum of 14 days before they take place, that the agenda for these meetings be mailed out to your ownership. And most of our clients are just finding that, and this is true for board meetings as well, that it's easier to schedule these things in advance. We have a lot of clients that actually at the second to last or last board meeting of the year plan out the schedule for all of the board meeting, committee meeting dates and everything for the coming calendar year, put them onto a schedule, mail them out to the owners at the beginning of the year with a copy of the general agenda for each of the different meeting types. And that essentially eliminates the need to then send individual notices and mailings and agendas for all of those meetings 2 weeks before they happen. So it may not be required, but it might be the most practical way to approach your ACC and board meetings, just depending on the size and the frequency of requests and, the requirements in your governing documents. All right, next question. What happens if we don't follow all of the mandates in RCW 6490-530, which is about financial statements and association funds? In particular, the requirement to prepare an annual financial statement using accrual-based accounting and have an annual audit by a CPA done if the annual assessments are over $50,000. The person's provided a bunch of details about the difficulty of getting a response from an accountant, as well as the cost of an audit, which is about $3,000 for this particular community, and said that they believe these requirements are onerous. What we've been doing for 45 years is working and doesn't cost any extra money. And I just want to make sure we're not going to face any fines or jail time for not performing the 2 items listed above. So the short answer to this question is, first of all, these are civil statutes. So the likelihood of any criminal penalties for failure to comply is very low. However, the possibility of financial liability is certainly there. And I would think it is exacerbated if it can be proved that the board knew about these requirements and willfully chose not to comply with them. So the risk here, every decision that you all make as board members, it's and on some level involves a question of evaluating risks and determining when a risk is appropriate for your community and when it isn't. The primary risk is that an owner would sue the association for failure to follow the statute, and they might assert that they have damages as a result. Damages might be difficult to prove, but it would probably be pretty easy for the owner to at least get a court order requiring the association to follow the statutory requirements, because you guys are clearly not qualified for the exemptions that exist in the statute. And if they do get that court order, they might be considered a prevailing party in that lawsuit, in which case they would be entitled to an award of their attorney's fees for bringing that lawsuit. So now you thought that what you were avoiding was the cost of a $3,000 audit, but if an owner files a lawsuit against the association and secures this court order requiring you to do the audit, you have to spend the $3,000 on the audit anyways, plus you have to pay your attorney's fees, plus you have to pay the owner's attorney's fees. All of a sudden that $3,000 decision turned into a $50,000 decision. So you're weighing the cost of different decisions and the likelihood of each outcome as you make these decisions. We do agree that there are a lot of statutory provisions that seem onerous or unnecessary for smaller communities, and the carve-outs that exist for communities that can opt out of WUCIOA don't allow those communities to opt out of things like the audits. But I also think that the statutory requirements are really clear, and I would rather not have to go to court on behalf of a client and say, yes, Your Honor, they knew about the requirement, and yes, Your Honor, they chose not to do it anyways, but please don't throw the book at my client, right? So that's the risk you're trying to evaluate. Sometimes you can mitigate risk by having insurance. So one form of insurance that typically covers mistakes made in good faith is D&O or fidelity insurance, right? The problem is this type of insurance provides coverage for mistakes made in good faith, not intentional violations of statute. And so another risk is that knowingly failing to do the audit might basically void any insurance that you have for that type of decision. And then I would also be remiss if I did not point out the fact that we have absolutely had clients where managers or treasurers have stolen money in the tens of thousands or hundreds of thousands of dollars from a community, and an audit would have discovered that loss sooner than it was discovered. So you're not just evaluating the risk of an owner lawsuit. You're not just evaluating the risk of the $3,000 audit versus the $50,000 cost if you lose a lawsuit. And $50,000 is just a ballpark. It could be way more. It could be a little bit less. You're also evaluating the risk of not catching financial mistakes or embezzlement or theft sooner if those things happen. So you're not going to go to jail. There isn't a fine that's provided for in the statute, but there is absolutely risk in willingly or willfully ignoring these statutory requirements. The last thing I'll point out is WUCIOA for All has not yet taken effect. And until there are court cases that tell us what's going to happen if a community knows about these requirements and ignores them, the best that we can do is make educated guesses. And part of our job as attorneys for our clients anyways, is to help them understand and weigh various risks, but also to help them avoid and mitigate risk. I would not feel comfortable telling a client that it was okay to ignore a clear statutory requirement. Tima, did you have anything you wanted to add to that one?
Nope, I agree with what you've said. And, like we said, we do understand some of these provisions seem burdensome at this time. And, but the risk of not complying is probably not in your best interest. So,
Right.
we will have to see what the courts decide as things play out. We just simply don't have any authority yet from the courts.
We have some follow-up questions that are related to the audit, so I'm going to just go ahead and cover those really quickly. One is, what year does the audit requirement start for non-WUCIOA communities, I'm assuming? This particular provision of WUCIOA does not apply to everyone until January 1 of 2028. So this is not one of the ones that goes into effect early for non-WUCIOA communities. If your community is governed by WUCIOA already, then the audit requirement already exists. If you're not, then Google your governing statute and the word audit and see what is currently required and allowed for your community. Most of the statutes do still require an annual audit by an independent certified public accountant, meaning not an internal audit, not a partial audit, not a whatever. And for those statutes that allow a community to opt out of audits, you are required to have a community-wide vote to opt out of the audit every single year in order to do that. In other words, the vote to opt out of the audit isn't like a once and done forever kind of thing. So again, if you just Google RCW, whatever your statute is, RCW 6438 if you're an HOA Act community, RCW 6432 if you're an old condo act, RCW 6434 if you're a new condo act community. Google your statute plus the word audit, and then you can find the audit provision that applies to you until January 1, 2028. There was another question that said, is it an annual audit or is it required on a different frequency? It is an annual audit. That is the statutory requirement. There's another follow-up question. What are the audit requirements under the upcoming laws? Can a review audit suffice for small organizations? A full audit is often overkill and very expensive. Oh, I'm sorry. It looks like I copied and pasted that exact same question twice in a row. So I was going to read it all again. I think my answers thus far have already covered this. It is a full audit. It has to be by an independent certified public accountant, and it is an annual requirement. And once the new law takes effect, there is no provision allowing communities to opt out once their assessments reach a certain threshold. So only very, very small communities might have the option of opting out. I'm going to move on from the audit topic. We've got other follow-up questions in the chat. And the next one is, if only a general agenda is sent at the beginning of each year, is it still best practice to have owner comments at the beginning of the meeting? Yes. It's not just best practice. It's going to be required by the statute. So under the WUCIOA meetings provision, which will apply to everybody January 1 of 2026, you have to have a 15-minute owner comment period at the beginning of every board meeting, period, full stop, end of story. This is true whether you send out an annual meeting schedule a year in advance with a general agenda, or whether you send out notice of each individual board meeting with a specific agenda each meeting that you hold. Do also keep in mind that the statutes require that a copy of the board packet, excluding any sort of attorney-client privileged or otherwise private information, whatever packet the board is relying on in each meeting to make its decisions, a copy of that has to be made available to owners upon request at the board meeting. So if you're holding your board meeting via Zoom, for example, you should prepare ahead of time a PDF that you can drop into the chat to show owners the financials and any other information that the board is relying on for that month's meeting. keeping in mind anything that should be redacted or removed from that packet, such as any attorney-client privileged information or anything else that's required to be redacted or kept private by the statutes. And if you're curious about what those things might be, if you Google your governing statute and the word records, you'll go to the records section for your statute, which has all of that information in it. All right, next question. If there was a scenario where there was only one board member left, how should the board handle that if there are no volunteers? This is a great question. We've covered it, I would say, probably a dozen times in the last couple of years on previous Q&As, and we don't have time to do like a deep dive into this today. So I'll just give a real quick overview and then point you to look at previous Q&A videos for additional details. One of the things that I will say is we tell our clients as often as possible to not ever let it get to this point, right? And I realize that for this person submitting the question, this might be a like the ship has already sailed kind of situation, but I think it's still worth repeating. Don't ever let it get to the point where you're down to a last person standing. The other thing I'll remind you about is that provision of the statute we talked about earlier today, which says that a board member serves until their successor takes office. And part of what you can try to do is strongly encourage that last board member to stay on until a successor is either appointed or elected to take office. I also think one of the things that makes sense is communicating with the ownership as a whole about the risk of operating without anybody seated on the board and the potential cost involved with that, because essentially what's going to happen is if you have a management company, they're going to essentially end up running your community instead of the board. And most of the management contracts that we review these days don't contemplate and cost a lot more money if they're doing everything that the board would otherwise be doing, including making decisions on behalf of the association. And also, I think then you start to look at liability related things too, right? If it's just sort of like routine stuff, like sending fine notices and collecting assessment payments and paying your normal vendors for like the landscaping contract, having your management company handle that sort of day-to-day business. I mean, that's what you hire a management company for anyways, right? But having a management company making decisions about next year's budget, having your management company making decisions about a special assessment, about an HOA loan, about larger maintenance issues, then it starts to calls those decisions into question, and sort of the magnitude of the decision as the magnitude of the issue increases, so does the risk to the community in not having a fully seated board. We have very, very rarely heard about communities where, because of the failure to seat a board, a court case was filed in order to get a receiver appointed to run the community instead of the board. That's really, really, really expensive. So maybe part of the gameplay is communicate with the ownership, say, listen, y'all, we are down to our last board member. They want to resign, they're selling their unit, whatever the thing is, right? If people do not volunteer to be seated on the board, your assessments are going to go up 50% next year because of the cost of having the manager do all the work that the board otherwise does. So the idea, of course, is to try not to let it get this far, but those are some pointers if it has gotten that far. And again, I would point you to some earlier Q&A videos where we've covered this topic in a little bit more detail. Tima, did you have anything you wanted to add to that one before I keep jumping on to the next one?
I would just say that in general, recruiting board members you should try to have, that should be an ongoing effort in general, and doing your best to make that role something that is, to encourage that role in the community, and to encourage unit owners, homeowners to be board members, because that to avoid this from happening, as Valerie said, this is the worst case scenario. You don't want to let it get to this point. When you're dwindling down to a very minimal board, that is where you do want to make sure that the existing board and that the community is aware of the requirement of having board members to run the community, to make these decisions, and to make it, I suppose, as appealing as you can. But if you have active community members, active owners, and certainly encourage them to be on the board. When we work with homeowners, obviously on certain matters in our law firm, and some of them have a lot of questions and they want to be involved, and this is a great way for them to be involved, is to be on the board. So it doesn't have to be it shouldn't get down to the level where you simply have no board members left. It really should hopefully not get to that point. We realize that can happen, but so.
Well, and one of the other things that I will say is that this is a great sales pitch for a professional management company. If part of the reason that your community has a dearth of volunteers to serve on the board is because board members are putting in 10, 15, 20 hours a week on their volunteer side gig, it might be time for your community to consider hiring a professional management company that can take on a lot of the day-to-day work involved in the sort of the nuts and bolts of managing the community. So the board can take more of a governance and an advisory, like directive role, as opposed to the board actually doing all of that daily management work. We joke often, I joke often, that it's a wonder to me how many people are willing to serve on the board of directors, because there's always somebody who thinks you're doing a crappy job. The pay sucks, right? Because you guys are volunteers, you're not getting paid. It's a lot of time. And most of the people that I know that serve on a board of directors are doing it because they want to benefit their community in some way. And if the burden on board members is too great, look to ways to reduce that burden rather than just pointing fingers at board members and saying that they suck for quitting. Not that anybody here is saying that, but anyways.
And if you're a self-managed community, for example, I represent all the self-managed communities at our law firm, and if you're a self-managed community, and part of the reason you can't retain or obtain board members is because of that that perceived unduly burdensome task of the administrative elements, you might want to consider hiring a management company, and that would provide some guidance, some that would reduce some of the perceived burden and actual burden upon some of these board members that feel like they're taking on roles that are too much for them. It may actually make sense to hire a management company, and from a long-term perspective, in the best interest of the community, to do that. I mean, I certainly can't make that decision, but I sometimes recommend it when these things are happening. In any case, yeah.
I think we can sneak one last question in. Is it legal in a resale certificate to say bylaws/rules available upon request, or must links be provided to the exact declarations, bylaws, and rules? Would an HOA be liable if exact copies were not presented? No, it is not legal, and yes, you might be liable. The resale certificate statutes are very clear that copies of the governing documents must be provided. I realize that a lot of resale certificates these days are produced electronically, and I don't think that it's unreasonable for the resale certificate itself to contain a hyperlink to a free copy of the governing documents that are required in the resale certificate statute. But I do think that you would be in violation of the statute if you said available upon request, or if you did not provide I'm not sure what else you would provide other than the exact declarations, bylaws, and rules. I'm also just going to take this really brief opportunity to remind everybody that terminology matters. And I think a lot of folks use bylaws to mean all the governing documents, or use these terms interchangeably. I want to remind everybody that these documents are named differently because they are different and they do different things. They serve different functions. And I think probably 6 weeks or 2 months ago, we did a real quick primer on the governing documents, the terminology for them, sort of the general hierarchy for them. And if you don't know what the heck I'm talking about right now, try to find that video in the Q&A, in the YouTube channel for our Q&A, so you can have a refresher on the correct terminology and the hierarchy of the governing documents. That takes us to 10:59. So I don't think we have time for any other questions, but we really appreciate you all for being here, and we will see you next week.
Have a great day.